So we're gonna get started. We're gonna continue a little bit on what Ash talked about, talk about some other points of the sunset and what can some alternative strategies to just insurance. So I've got here Chris Cahill from 12 Points and also Kurt Steinkraus from Mintz 11. I've known Kurt a really long time. We went to high school together. We separated for a while, but now lucky enough to get back together. Kurt is probably the preeminent business and estate planning attorney in Boston. And so I'm very honored to have him here with us from Mintz 11.
So Kurt, thank you for joining us. As Dave indicated, I've also known Kurt for over 20 years now. Had the pleasure of working with him and the team at Mintz. Excellent trust and estate business planning, works with business owners, is a co-chair of the private equity firm at the firm as well. So we're really honored to have you here today. And we're going to spend a couple of minutes just kind of going over a little bit of the ground that was covered by, and I'll give you Kurt's information. You can take a picture of this now, but you can see it at the end as well. And of course, this is me. But we're going to go over a little bit of the information that Ash went over in Hancock. Thank you very much, Tracy. Great job. But obviously, the Tax Cuts and Jobs Act is on everybody's mind, especially those of us in this business, in this room here today. It is the topic of discussion that I'm having with my clients and that we are 12 Points with our large clients. We refer to this as the golden age of planning. There's no better time than now to be talking with your clients about what's going to happen in the future. We all know where the exemption's been. We're not certain where it's going, but we believe that it's going to be somewhere around 7 if we don't get some sort of reconciliation. When you're talking to clients, what are you seeing and discussing here with regard to the crystal ball for 2026?
My crystal ball? I don't know. My guessing days are over after 2016. I'm just planning on the fact that this law will expire. There will be no reconciliation, and then we just have to plan accordingly. You know, I don't know where we're going to go, all blue, all red, but I'm feeling it's going to be a combination of the two. And that's going to probably be a good thing, but it's also going to mean it's going to be hard to, you know, as everybody in the room probably knows, and the clients get confused on this, like they think, well, maybe it won't happen. No. It's set to expire. So we'll take an act of Congress to actually do something different. And there's going to be a lot of horse trading. You talked about the estate tax amounts and, you know, so I'm just going off the assumption that's going to go away. We all went through this, everyone in this room, 2012, we'll go through this later on, but I think we should plan for the fact that it's gonna expire. Some people are really worried that if we go all blue, that they could do something next year, retroactive to the beginning of 25. So if you have very large, unlikely, but I don't want to be that advisor that's telling the really wealthy client, you know, don't worry about it. I mean, if you have enough money, you can give it away, do it now. Like, you know, why wait till next year when we'll talk about some of the other challenges you're going to face or the clients are going to face if they wait till next year?
A great point. And as you brought up here, we've seen this movie before. You know, we've been in the business long enough. Everybody in this room has candidly been in the business long enough to have had clients come to them and say, what am I going to do when the tax law changes, right? 2012, complete nightmare. You know, the end of 2021. Who knows what's going to happen this year? So,
well, I would add, if you remember, that happened after 2012. Remember that? You know, they, you know, so everybody went through hell, and then in January they're like, we'll give you the break. But at that point, we'd already did all the work. So that I don't even know if they would argue that they took action in the 11th hours and the 13th hour.
So who knows, right? But better to be prepared, as the old Boy Scout motto goes, right? Time is of the essence. We need to act quickly and truthfully. I thought it was important to put it in days. So there's 457 days from today, calendar days, between now and 12/31/2025. If you take out weekends and holidays, there's only 311. Is that better? Thank you. So we have 311 business days. But in truth be told, as Ash brought up, you got to get this stuff done early. So we're really kind of looking at about half that time, because basically, you know, you're going to be booked and not doing this work after Labor Day next year, right? Not for new clients.
I would say never to say never. If a billionaire walks in the door, I'm going to make room for, you know, that. But it, you know, there are definitely going to be challenges, and I know Chris is going to touch on this. But when we went through this before, it's not just the lawyer. You know, there's a lot of other people involved, and when you do gifting, You got to be able to open up accounts with financial institutions. You know, there were a number of financial institutions that shut down. Professional trust companies said, we're not onboarding new clients. You know, the IRS shut down their system. If you remember that, you know, you couldn't get EINs at the end of 2012. The valuation people, they're
They're the worst. You're absolutely right.
absolutely. That is your, you know, tallest pole in the tent. They're the ones that really, you know, we'll talk about some of the strategies around what you can do now to avoid that. But it's not just, you know, finding a lawyer to draft the trust. You know, you got to get the trust drafted. You got to open up the account at a financial institution. You go through all the KYC stuff. You know, get an EIN. You know, get the trustees on board, and then of course fund the trust with the assets that you want to fund it with.
Right, and that's critical to those of us in the room here, which is all of us that are working with business owners. Because if we're business assets to transfer, you got to value it. You're not going to be able to do it quickly. It's going to be complex. It's going to take time. If you're dealing with real estate assets, same sort of thing. If you happen to be blessed with a client that came to you and said, hey, I've got 50 million of liquid investments in the form of Apple, Amazon, Netflix, Google, perfect. Send that stuff to a trust. There's no valuations necessary. But one would submit to you, I would submit to you that using those assets straight up without doing something else to them probably isn't the best use of the asset. You're not going to be able to get a discount there. So you might want to think about more advanced structures, i.e. LLPs, LLCs, et cetera. So, but we want to be deliberate and thoughtful, right? The last thing we want to do is wake up in 2026 and say, have planning remorse, right? And feel like, oh crap, we gave away too much or we didn't do it thoughtfully enough, right? So we really need to make sure that we're doing thoughtful planning and that we're paying attention to the best assets to give away. And that's the most critical thing. Highest growth assets, those are the things that we can distance ourselves from. Those are the ones that we want to be utilizing. And then, you know, of course, we want to make sure that we have a team in place that can administer the gift once it's been completed. Because the reality is that you need to have systems and processes in place. You need to have trustees that can manage the estate and the assets well, and to prevent that that bad situation. So building flexibility and
and speed kills. You know, when you go too fast, you know, you make mistakes, and some people say, well, you can fix that. That can be fixed. This can be fixed. You can always, you know, maybe amend the trust or change some provisions. But
you don't want to be relying on that, though.
You do not want to be relying on that. And two, there are some things you cannot fix. So, for example, if you've got a large client that's going to make a $28 million gift, and they just last minute throw that into a trust in a state that has what's called the rule against perpetuities. You guys had I think the slides up earlier on some generational stuff, but you know, a lot of states have rules against perpetuities, meaning that states created in Massachusetts, for example, cannot last forever. And for really, really wealthy clients, that really matters. And they're going to be pissed if they find out that they had options to go to other states like Delaware and Florida and New Hampshire and Alaska and South Dakota and all these other states that have either repealed their rule against perpetuities or have significantly increased it, like Florida. Because one day they'll be at a cocktail party and over the weekend. And there are two things that I enjoy the most: the Wall Street Journal over the weekend, because I get more phone calls from that. And in the summertime, the cocktail party, you know, phone call I get on Monday morning saying, I was at a party over the weekend. One of my friends has a dynasty trust. Do I have one of those?
Or I'll say, yeah, why don't I?
Or why don't I have a dynasty trust? And I'll say, remember that time I told you that story that you'd come back and you would tell me this? This is the time. I literally have had this conversation.
For sure. And we will have this conversation, you and I, with regard to the client that moved to Florida, because we spoke to them specifically about doing a dynasty trust. And they said, no, Massachusetts is fine. We spent a half hour afterwards explaining to them why they wanted to do the trust in Florida. They didn't. They've now since moved because of the Massachusetts income tax changes. And I'm certain that that's going to be a topic of discussion. So we should revisit that with them soon.
Yeah, but the point being about, it's hard to be thoughtful when you're moving fast. And when you're creating trusts outside of your home state, you need to find a resident of that state to be the trustee. And they'll say, oh, my brother-in-law has a condo in Florida. No, they need to be a tax resident of Florida, or you need a professional trustee down there. And that involves, time. So
let's spend
that's
one
the challenge.
while we're talking about Florida and time.
Yeah.
Everybody in Massachusetts is moving to Florida, all of our large clients. I don't know about the rest of you all in the jurisdictions that you live in, but there's tax refugees going on everywhere. They're moving to Florida, they're moving to Texas. Spend a minute, if you will, Kurt, talking about what it means to become a resident of Florida for the purposes of taxation.
How many blue states do we have in the room? Are you guys from? Mostly, or red states, 50-50? I mean, how many people worry about state income taxes?
We don't know, right?
Minnesota, yeah. So I mean, at least in the blue states, this is a hot topic, in Massachusetts in particular. Now that we have a millionaire's tax, so we're now taxing our income at 9% over $1 million. So that is pushing people out of Massachusetts a lot faster than even before. And any income,
Capital
any
gains.
income. Once you go over $1 million, you start paying at 9%. And it could be from your sale of your business, it could be compensation income, it doesn't matter. That first dollar starts getting taxed at 9%. We are Taxachusetts for a reason. Although Belichick tried to blame it on why the Patriots couldn't get free agents.
Yeah, that was interesting.
It just came into effect. So I'm not quite sure that was the reason why they couldn't sign free agents. But so I've been doing this for about 30 years, and I would probably tell you I had like 3 or 4 state income tax audits. Now I have 3 or 4 state income tax audits going on right now. And so all the blue states are hiring people. New York has offices in Florida to handle their audits. They have so many. And so, to Chris's point, people say, okay, no problem. I'm out of my blue state for more than 6 months in a day. Well, that is true. That is your first step. You need to be out of your home state that you're trying to leave by more than 6 months in a day. But the problem is our wealthy clients have homes and boats all over the place.
Mm-hmm.
So they don't realize that when you leave one place, you have to firmly establish a residency somewhere else. And if you don't establish a residency somewhere else, you'll default back to your home residence. I'm in the middle of an audit right now, and my client probably spends 40 to 50 days in Massachusetts over the last 5 years. That's it. But never spent more than probably 80 days in Florida for the last 4 or 5 days, where they're saying they're a resident of, because they're all over the place. And we're in a fight, and they're probably going to lose, and there's not much I can do about it, because you got to do those 2 things. And then home is where the heart is.
Mm-hmm.
People seem to forget that unless you're Whitey Bulger and you lived, from currency for the 1980s and a hole in the wall of cash, and you literally were off the radar, you cannot live off the radar. Your cell phone, your credit card bills, your easy passes, your ATM, and they look at all of that, and they look at your medical records, and they look at your vet bills, and they look at, your doctors. Everything is, the vet stuff is a big one.
Yeah, for sure.
There have been 2 cases that have come down to that, because home is where their heart is. So it's days out of the state you're trying to leave, establishing your residency in the state, by spending 6 months in a day there for as many years as you can, and then doing everything else you should be doing in terms of making it your home. Bring your pet to Florida. I mean, like if you're saying you're a Florida resident and you never bring your animal there, and they don't ever, see a vet there, is that really where your home is? Like if I'm moving to Florida, Chip and Oreo are coming with me. And I should have put pictures of them up there. But yeah, no, so, and I know you guys are, maybe not on the front line of this, but you could spot an issue and save a client a lot of headaches.
We don't really know what's going to happen here. And I think, as Kurt indicated, it's good practice to plan for a sunset of the exemption. There's any number of things that could happen. Tax rates could stay the same. The exemption amount could change. They could repeal it completely, unlikely. They could find a middle ground. Most likely we're going to get sunset. If you get that blue wave though, you might get something that's a little bit more disconcerting for those of us that are planners. So uncertain, but what we do know is that we have the ability to plan, and for people with significant wealth, now is the time. So let's talk about some of these strategies. So Ash and Tracy talked about slats. We've touched on dynasty trusts, but let's dive into what you're seeing, what you're doing in your practice, Kurt, here on the left.
So this probably, three different main types of clients. The clients that even with the exemption dropping down are still going to be under the threshold, they don't have to worry much about it. And that's just a matter of at least getting the low hanging fruit out of their estate. Is the life insurance out of the estate, things like that. Then there's the other extreme, which is the really wealthy client that's not going to miss, giving away $28 million, and that's just a no-brainer. But for the middle, which is where most of the action is, you've got these tweeners that, are sort of hovering around $28 million. And, and everybody that's not familiar with the SLAT, spousal lifetime access trust, right? It is the proverbial have your cake and eat it too, where, spouse creates a trust, bless you, for other spouse and kids. And, that let's, just say, wife creates a trust for husband and kids. Wife has a business, wife's successful, wife earned all this income, creates a trust for husband and kids, uses it up her exemption, right? You can't split that gift that doesn't use his exemption. So that's a way to utilize at least one of the spouse's exemption. For my clients that are on the fence and don't have a lot of assets, that's the strategy I say. Use up all of one of the spouse's exemptions. Don't touch any of the other spouse's exemption. So when it goes from 14 to 7, husband still has 7 million to give away. Wife gave away 14. So at least you still got 21 million. And for a lot of people, that's all they need to do. Because where it gets confusing is people think when the exemption is going to drop from 14 to 7, that it's dropping from the top. Meaning, like if I gave $4 million of gifts, I'm sure you guys know this, and now I'm down to 10, and the law changes, they think, oh, I'll just go down to 7, I'll still have 7. And we know you come from the bottom, not from the top. So if you gave away 4 million during your lifetime, now you got 3 left. And that creates a lot of confusion as well. So one thing we say is, look, just maximize one of the spouses. And you guys will like this because I am pro-life insurance. And what I will say a lot to my clients, and I will push them on this, is say, look, wife's creating a trust for husband and kids. Wife has access to that trust as long as
Husband has access.
Well, wife. Wife has access to the trust through husband.
Correct.
Right, and that's what people are really worried about. Of course, husband's a beneficiary of that trust and will have access to it. But what people really worry about is that we're both going to have access to this. Both the grantor and the spouse is the beneficiary. And so what are the 2 ways you can no longer be a beneficiary of a trust?
Death and divorce.
And divorce. Now, not every trust says spouse comes out of divorce, but most states, most trusts will say, if we get divorced, spouse comes out, which is fair. It's not trying to penalize one or the other. It's just trying to level the playing field a little bit so neither party gets whipsawed. So, if they're hopefully in a good marriage, the real risk becomes death. And so what I'll tell a lot of my clients is that, look, wife, load up trust for husband and kids. And now the only thing you're really worried about is if he dies before you. So go get life insurance on him. So now you've hedged that risk. So now you've got maybe an eyelid over here that she's a beneficiary of that just holds life insurance on his life. So if he dies before her, she loses access to that trust through him, but she just picked up $5 or $10 million of insurance over here. So, and then, and of course, the thing that gets asked of me every single day of the week and twice on Sunday is, if my spouse is creating a trust for me and the kids, why can't he create a trust for me and the kids, right? The reciprocal, what's good for the goose is good for the gander. And I would tell you exactly that that's very risky, and you are poking the bear being the IRS. And I didn't go deep into
being recorded telling people don't do that.
Yes, well, yes. And I used to work at the IRS, and I tell them we weren't stupid. We're just outnumbered. But once you get audited, the leverage clearly shifts to our side now, and because then it's not now it's an unfair fight. They've got you, and you're just poking the bear when you do these reciprocal slaps. And
So let's talk for a little bit about
please.
how we plan there. What's the strategy around that?
Well,
that we
again,
utilize?
the best strategy is you need time. One of the things where these things you can do, husband can create a trust for wife and kids, wife can create a trust for husband and kids, but you can't do it at the same time. And you can't do it with the same as, like, basically if wife's the earner in this example, and she can't just take the assets that she's earned, give it to husband, who then turns around and creates a trust for wife and kids, right? Because that was her money. And I know if you get divorced, it's 50-50, but the IRS cares about, who earned the money and where did it come from. The tracing is a real thing. So, the only way you can really have sort of non-reciprocal slats is that you need time in between them. They need to be certainly can't look the same. The different trustees, different provisions, different powers, different states. There's a long list of things you do to try to make them so they're not exactly reciprocal. But the biggest thing that you can't do is create them at the same time. Yeah. But this comes up a lot. And you guys have to worry about it in the insurance world because you're constantly buying insurance for husband and wife, and you do two ILETs at the same time. You're probably technically, they're probably completely reciprocal. But if all you're doing is buying life insurance with them and not utilizing gifts,
service isn't really going to lean on that too bad.
Probably not. That's probably not the hill they're going to die on. But the moral of the story is, this is a great technique. I've been doing it for years. This isn't something new. Going back to the beginning of my career, we've been utilizing spouses as beneficiaries of trusts. But you just could be usually we'll do, one spouse creates a slat, the other spouse creates one just for the kids only. Right. And
that removes that issue completely.
Right. And if you're that worried about, losing access, then buy insurance on the other spouse and hedge the risk.
Right. And that strategy works perfectly well for large estates. So the client that Kurt and I just worked on recently is worth north of $350 million now. So we did a slat for the husband for the benefit of the wife. So he was a grantor, and then she's just created a trust for the benefit of the kids. There's no need for that money to come back to him. Just that strategy just was best to keep them far afield from that.
Yeah. Yeah. But yeah, so the other things we're doing, number 5 is during your lifetime, you can create a marital trust called a lifetime Q-tip trust, the qualified terminal interest property trust. But basically it's a lifetime marital trust. So you could fund it, but then you have until the gift tax return to decide whether or not you want to, have it qualify as a marital deduction. So there's no gift, or you can not elect to do that and end up using up some of your exemption. So that's a way to kind of wait and see, how things are going to go. The other thing we're suggesting to clients, and we'll talk about this over here in a second, but particularly with the exemption going up another $500,000 next year, and you don't have to go out and get something revalued, is to do a sale to a trust, take back a promissory note, and then forgive the promissory note as the gift. And that way you could do part gift, part sale. Let's say they're ready to do something now, and they want to utilize their full 14 million, but they don't have 14 million yet. It's going to go up next year. So, we'll do a gift, sell the difference, take back a promissory note. And then next year, all you have to do is forgive the rest of that note. And there's the rest of your gift. You're not going through the whole mechanics of getting something revalued and getting appraiser involved.
Great point. So the sales to defective trusts, let's talk about that for a second. Obviously, one of the best techniques from an estate freeze perspective, right?
Yep.
You have a business interest that's growing at 15% a year, hypothetically. Let's walk through what that would look like.
So the big thing is, if anybody has business owners, the biggest mistake I see when I come in is that people treat their businesses like hot potatoes, and they realize they know there's an estate tax out there. They know that there's going to be an issue if they die. And so it starts heating up in their hands, and then they just start giving shares to the kids. And the problem with that is once your kids have shares in the company, it's one, it's includable in their estate. 2, it's reachable by their creditors, bankruptcy, litigation, and most importantly, divorce. I am not a divorce lawyer, but I swear to God, I feel like one, because out of the, roughly 800 estate plans that I've done, that is what people worry about the most, that their kids are going to get, married and their kids are going to get divorced. And, we do a lot of prenups, but that's no walk in the park either. And, to tell your kid that you want them to get divorced before they get married, which is what a prenup is. And there's a lot of other pitfalls to prenups, but, look, in a lot of situations, it's the right answer. And some situations, it's
To non.
the hill's too tall to climb. And so, but you default back to saying, okay, and I just had this conversation last week with a client, say, hey, my kid's getting married, they're a wealthy family, but I'm like, look, you could do the prenup, no doubt. That's belt and suspenders. And that's never a bad thing. May not be fashionable. I think you've got suspenders on, Chris, no?
Not today.
Usually, but no, but it is the most protective thing. But if not, the best way to protect it from divorce is to put things in trust. And Oliver Wendell Holmes in 1858 said, don't put your, trust in money, put your money in trust. I mean, think about how long people have been doing trust planning. There's a trust company in Boston that was formed before the Declaration of Independence was signed. I mean, that's how far back families have been utilizing trusts. And I'll say, look, the Mellons, the Kennedys, all the wealthy people, Rockefellers, the Vanderbilts, I mean, their wealth has sustained because people put things into trust. But so business owners often make the mistake of starting to give their shares to their kids.
Right.
So that's the first mistake. The second mistake is they also will inadvertently give up control. I mean, I've come into situations where they just kept giving away the shares every year to the kids. And the next thing you wake up one day and they only own 40% of the shares and there was only one class of stock and they gave away control. So never a good thing. So the first thing we tell our business owner clients is recapitalize the company, create voting and non-voting shares. The voting shares should represent about 1% of the underlying owner equity and 99% and now you've got currency. Now I've got non-voting shares that I can start to give away and I can maintain control, which is not a 2030, thankfully, usually not a 2036 issue. Then you get to where am I going to give those shares? And, so you can give them to a trust. But if the value is more than what you can give away, we end up selling a lot of those shares to the trust, take back a promissory note and sort of freeze that value. And then it's sort of paid off over time. And, it's a very powerful technique. Yep, go ahead.
Yeah, Kurt, if you give it away to trust, right, and it's creating income, if there's income producing, then the trust will pay a lot more taxes, right?
Great question. So generally speaking, these trusts are going to be grantor trusts to the creator of the trust, meaning that they're going to show up on the grantor's tax return. And therefore, they're going to be at the same rate as the individual grantor. And if you're going to sell any interest to a trust, you want that trust generally to be a grantor trust so that it's not a taxable sale. If that's a non-grantor trust or a complex trust, then you're right. That would, one, generate a taxable event when the grantor sells shares to that trust. And two, when that trust is getting income, the brackets are condensed. And that's why by the way, dorky moment here. Hold on, I won't forget you. But if you're wondering why the grantor trust rules apply, is that it used to be that, trusts had better brackets than individuals. And so people were intentionally putting things into trust to avoid paying as much in taxes. And the IRS said, hold on a second, we're going to close that door. So anything, now we want that trust to be taxable to you on your personal tax return, which at the time had higher brackets.
And now they're reversing that argument, of course.
So now you close one door, you open another.
But if you continue to do that, give away shares, keep doing that, then all the tax burden will be on the grantor.
Yes.
So how will the grantor fund that?
Yes. So that's a very good question. So another way to say it is that, these grantor trusts are very powerful. You are responsible for the income taxes on this trust. And that's one of the reasons why we always suggest to make it a slat. So your spouse is a beneficiary of that trust with the kids. And if there's ever a year that you don't want to pay the income taxes, the trustee can make a distribution to your spouse who's a beneficiary of the trust. And he or she can, give you that money tax-free as long as they're US citizens and use that money to pay the taxes. So that's your one safety valve. The second one is that you can have what's called the tax reimbursement provision in the trust to allow the trustees to reimburse you on your taxes. I don't love utilizing that, and I stay away from utilizing the reimbursement provisions.
And you definitely don't want to do it every year.
You don't want to do it every year, and there's this case recently, you may have seen it, where they added a tax reimbursement provision to a decanted trust, and that actually created adverse tax consequences to the beneficiaries, because you're basically adding a beneficiary when you do that. You know, the grantor is kind of a beneficiary of that trust. So you're very right. You got to be very careful that you're not, you know, bankrupting the grantor on these grantor trusts. And that's why if they don't have a spouse that's a beneficiary of that trust, you got to tread carefully. And a lot of times what we'll end up doing is, you know, it's a grantor trust. You know, you got to seed gift it, right? You got to remember, you can't just sell to a naked trust. You got to have at least 10% of equity in that trust. And then you sell to that trust, take back the note. And then once the note is paid off, and if your spouse is not a beneficiary, we'll turn off the grantor status of that trust so that it'll just, you know, just pay its own taxes going forward.
Yeah, but Manny, that's a great question and excellent answer, Kurt. Thank you. But this is the stuff that's super important for business owners that are contemplating these transactions. You can't wait until November, December of next year to be doing this sort of thing, because the most important thing to a business owner, aside from their concern about their kids getting divorced, is their cash flow. So those are the two biggest things. Don't play with their kids, don't play with their cash flow. So you need to make sure that there's going to be enough there. Yes, David.
Kurt, I'm actually going to ask a question that was very relevant to a business owner that we just had. So business owner has a business 50-50 with his brother. Their buy-sell agreement is way old. So we suggest they should get a renewed buy-sell. And the accounting firm came up with two valuations because they want to do their gifting too. So they came up with an insurance valuation at $53 million and a gifting valuation at $22 million. I was a little uncomfortable with that.
Yeah.
Having worked at the IRS, I'd love to hear your thought on that matter.
Yeah. I think whenever you have two different valuations floating around there, that's never a good thing. It's hard to argue that that's the value is the lower value for gifting when you've just entered into, a contract with an unrelated party. I mean, I love buy-sell agreements for, that exact situation because, unrelated willing buyer, willing seller sits down and negotiates, a price. That's a good indicator of what the true value is. So yeah, I'd be concerned about that. You guys may have touched on this before, but the whole redemption, did you talk about that?
We touched on it briefly, but let's get Conley again. It makes perfect sense.
Yeah, well, basically, I mean, this has always been the fear and just the reset, the topic, but for buy-sell purposes, you can have two different ways you can buy out shareholders. There's a redemption, so the company owns the policy and then takes the money and redeems one or more of the that owner with that with the money that came into the company. And the question has always been, if you have $10 million of life insurance on Chris, and Chris is a 1/3 owner of this business, and I redeem out his shares, what's the value of his shares? Does that include the value of the life insurance? And, people were always saying, well, how can it really increase the value when it's going to be used to immediately be, it's a liability. And I think people sort of felt comfortable that it wouldn't be that. And of course, Conley said the opposite, that it will increase the value, for estate tax purposes.
Earlier, you talked about the prenups.
Yeah.
And, very common, tool, obviously.
Yeah.
I have cases where some kids didn't get their prenups done.
Yep.
And the planning's being done. And, the ultimatums have been laid down where you had to have the prenup or you're out.
Yeah.
So post-nups are coming up.
Yeah.
Can you talk a little bit about your view on the effectiveness of the post-nup?
Yeah, great questions. And I'll go back to the buy-sell too in a second. But so first thing is a lot of my clients will like to put that language in their trust saying, if you don't have a prenup, you're out. That arguably is against public policy, may not be enforceable. It's a state-by-state analysis, but I am leery of putting shalls in my trust documents. I think the best thing is you want a lot of discretion in your trust documents, and you want very strong side letters, precatory letters, letters of wishes. I also do probate litigation. I've been in court off and on for the last couple of years on 4 or 5 different, probate matters, families with money equals fighting. And so, and of course, the only people that win are the lawyers, and that is true. But I don't wish it upon them, but when they're fighting, they need to be defended or they need to be advocated for. But either way, so the first thing is, I'm not sure that's going to be enforceable. And I don't know if I would ever put that. I don't put those things in my trust documents, because what if the beneficiary didn't even know about it and they just got married and then they inadvertently get kicked out? So that's one. But 2, people are coming in after the fact saying, look, let's do a post-nup. And that is a state-by-state thing as well. So not every state's recognize post-nups. I will tell you they're harder to do, believe it or not, than prenups, because prenup, there's consideration. The consideration is we're going to get married. It's kind of like restrictive covenants with non-competes and non-solicits. When you hire the person, you have an opportunity to say, Chris, I'm going to hire you. I want you to sign this non-solicit. But if I wait 5 years into our relationship, Chris, I forgot, sign this non-solicit. That's
sign that one real quick.
When you have a post-nup, and we do post-nups, you need more consideration than just, I'll divorce you if you don't do this, which people will often threaten you. But I can't, if I talk about prenups, I have to, of course, tell my favorite story about prenups, or I have a few stories, but the Seinfeld episode, I got to be careful with my Seinfeld references, because there are more younger people out there that don't get all my Seinfeld jokes. But when George didn't want to marry Susan anymore, Kramer said, ask her to sign a prenup, and she'll get so mad, she'll cancel one. Now, this is George Costanza. Okay, lives with his parents, no house, not even if he was working anymore, but he had the courage to say, I want you to sign a prenup. And Susan, of course, said, of course I'll sign one, I'm worth more than you. Which she was. She came from a wealthy family. And so I've told that joke to a few people, and they're like, oh yeah, my fiance's family has a ton of money. I'm like, well, they are reciprocal. So they generally are reciprocal, but we have had situations we come in on the back end and a kid wouldn't do it, and then we have to fight through the post-nup. But you have to give even more consideration to that person. And the other thing I would say about prenups and post-nups, and this is critical if we never meet again, both sides need to be separately adequately represented. That is the number one thing. They need representation. And if they do not have separate legal representation, that agreement will most likely be unenforceable. That is a very cute way. And I just went through this a couple months ago, where one of my client's kids said, oh, my fiance, she's fine. She's not even going to get a lawyer. I said, wow, she's either very savvy or she really does trust you. But either way, no, she's going to get a lawyer. Absolutely must get a lawyer. 2, this is the tricky part with clients, full disclosure. Mm-hmm. You have to tell them what's the value of the trust and what the expected inheritance could be. And 3, you can't have duress. You can't ask them to sign it, the last minute.
And can you give an example of that consideration concept?
In the post-op setting, it's like pornography. I'll let you know when I see it, but it's more than a toaster and probably, less than a house, but it's probably going to be, it could be $100,000. It could be, it's got to be some substance to it. I mean, it really depends on the size of the estate, right? If that person's got $1 billion and you're asking them to sign a post-nup and they're going to throw 50 grand at them. But yeah, so it really just depends on how sizable the estate is and what's at stake, but you got to have some substance behind it.
Let's spend the last couple of minutes just talking about, so this is the math. You guys have seen the math. You can pay the tax with insurance, section 6166, Cragen loans.
Yeah, we'll go back to that for a second. I mean, because I am, I pledge, to be a good life insurance proponent, because I do feel the value of it. People talk about these two things a lot. I've literally done almost 1,000 estate plans. I've done 166. They're very hard to pull off. And they also can really screw up your business, because you've got other creditors in there, you've got other banks. So a lot of my clients will say, I don't need to buy life insurance. I'm going to use 6166. And, there's even more, obviously Chris just touched on a few things there, but, if you have too many shareholders, you're not eligible for it. There's a lot of people think it's a closely held interest, but it's got to be not only closely held, but it's got to be, a certain lower amount of shareholders. The Gregan loans, those are harder and harder to come by as well in terms of being able to actually get that security and it's not, COVID days. So this is still, in my opinion, the best way to fund other than, good gifting and getting value out of your estate.
Right.
But, that's part one. And then part two is life insurance. And then you go down that line, sort of in that order.
So obviously the importance of planning with business interests, there's complexity, valuations, all of these things that we discussed earlier. Plan early, plan often, making sure that you pay attention to control on the business so that you're not giving up control. Very, very bad. Making sure that we have trustees that can manage it and that we've got a proper succession plan in place. Have a conversation. I don't know about you guys, but I'm seeing the kids don't want mom and dad's business. It's amazing. So what are we planning for? If the kids aren't going to come into the business, maybe we should be selling it, right? So don't be afraid of those conversations. And we're going to end quickly with one of
Oh, sorry,
Kirk's-
go back to 1 second.
Sure.
I know we're running out of time, but just to go back to the buy sells in the Conley case, 9 out of 10 times I do cross purchases anyways. Because you get the step up in basis, for the buyers, where you don't get that in a redemption, right? So if Chris and I are partners and the company owns the life insurance policy and just redeems him out, I go from a 50% owner to 100% owner, but my basis doesn't go up for the most part. But if I own the policy on him and I get the money and I, pay it to him and I buy those shares from him, my basis goes up because of that.
50%.
So that's one. Two, the life insurance is out of the company, so it's a little bit more protected over here. But I will say the hurdle in your world and my world, when we start doing cross purchase agreements, one, if there's a lot of shareholders, it gets nightmarish. And there are LLCs or trusts that will own those insurance policies on, the different owners of the company and that are you're a member of this LLC as long as you're still a shareholder in this entity, but that gets clunky too. But the hardest challenge with cross purchase agreements is getting the money out to pay the premiums. And when you tell a business owner that something is not deductible,
Their brain switches off.
It definitely, and that is the challenge, when you have to fund these cross purchase agreements, and the premiums are, pick a number, $80,000 a year. And it's the older partner that's buying the policy for the younger partner to buy him or her out. And then there's an awkward discussion about, why are you doing this for free to that person? Like, why are you just, you're bonusing them out $80,000 a year. Who's paying the taxes on that? So they can take the money and, pay for your premiums. So it's why I think there are so many redemption agreements, because it's just easier, right? I hate to say it, it's an easier sell. Right, because the company owns it, it's an asset of the company, the money stays in the company. Yeah, it's not deductible, but at least you haven't had to get it out of the company to pay the premiums.
So needless to say, reviewing buy-sell agreements, top tip of the day. That's what I know you guys are all doing anyway, but that's a way to generate tremendous business. And we will, in fact, end here on section 1202, one of Kurt's favorite topics. So let's spend a minute talking about C Corps.
So, and I know you guys could be someone's hero. And this is, I spot issues for clients outside of my area of expertise all the time. And there are clients to this day that will tell me the best thing you ever did for me was something over there that had nothing to do with legal issues. So even though you're not tasked with understanding section 1202, if you can spot it for one of your clients and be a hero, they'll be forever indebted to you. So basically, if you run across a client that has shares in a domestic C corporation, and they got those shares from the company when the value was under $50 million, and they've held those shares for more than 5 years, they can exclude the greater of 10 times their basis or $10 million per taxpayer. That's federally exempted. It's for income tax purposes. Yeah. This is an income tax. Thank you. This is just an income tax thing. So you own, you're just an angel investor, and you invested in a bunch of startups, and you put, $50,000 into 5 companies, and they're all C Corps, and you held those shares for more than 5 years, and then they're sold. For the most part, there's always exceptions, but for the most part, when those shares are sold, you do not have to pay income taxes on the first, let's, on average, $10 million of gain. And most states follow that as well. Not every state, like California doesn't. And some states, Massachusetts for a long time was only a 50% gain exclusion. Now it's 100%. So you could be someone's hero just by saying, hey, I understand you're doing some angel investing. Are you familiar with either Section 1202 or the qualified small business stock? There's a potential where you could save some money. You could even just leave it at that. When I hear early stage investing, I immediately think Section 1202. Does that have anything to do with life insurance? No. But, could you be someone's hero? Yes. Save them some money. It's a good thing. There's a whole other seminar on what else you can do on 1202, but that's the high level summary on it.
Next year.
Kurt,
Exactly.
I just want, Kurt, 2 minutes on, where does Mintz do business? Where do you do business? Where can you practice? Where does Mintz have offices?
Yeah, I appreciate that. I do, as Chris mentioned, I do corporate M&A. That's across the country. Estate planning, Northeast and Florida predominantly.
Including New York.
Yeah. Kind of New York and up to the, and because that's still, estate planning is still a hand-to-hand combat. People kind of want to touch and feel you. So, and every state, to someone's point about the state issues, like if they're in Oklahoma and they need an estate plan, I'm probably not going to be the person that's going to do that. But, mostly Northeast Florida. So many of my clients have moved to Florida.
Mm-hmm.
And, anybody that's worrying about estate taxes, generally speaking, and then some, it's just because, we're not the low cost provider. Any questions? This room's got a lot of good energy, I will say. But yeah, Heckerling's a great thing if you want to check it out. It's in Orlando. It used to be in Miami, South Beach, yeah. And then people would say, we should really be back to South Beach. I said, who are we kidding? We're tax dorks. We're meant to be in Orlando.
Yeah, truth be told, though, Kurt.
Yeah.
It was fun watching the tax attorneys and CPAs stumbling back.
Yeah.
Bars on stuff.
With white socks and sandals. That's just not a good look, Chris. That World Marriott in Orlando has the largest freestanding ballroom in North America. Yeah. It is. If you've been to that conference center, the Marriott, the World, it is meant for tax dorks. I mean, it is just, you walk by that hotel bar at 1 a.m. and, yeah, it's a very scary scene. Yeah, it is. Yeah, exactly. Gone wild.